I'm Steve Sussman, the Executive Director of the Civil Jury Project, and thank you very much for coming. We start these things while everyone is eating, and keep going through the line. There's plenty of food and dessert, and go back. And we're going to start the program while you're eating, because one commitment we make when we schedule these lunches is that we quit promptly at 1:30 regardless of where we are and how interesting the program is, because we have judges that want to get back to trying jury cases, and we have lawyers that want to get back to trying them, and fortunately the jurors have already served their duty and came here, and so there's no rush, but we'll stop promptly at 1:30. So I will begin now. I want to thank the sponsoring organizations and that are listed up here on the screen and the host firms. This is very typical. This is our 13th jury improvement lunch we have held at various places around the country. So it's like having to arrange like 13 weddings or bar mitzvahs. It takes a lot of effort. We come to a strange town, we rent a strange hall, we don't know what kind of... The food's better as we have gone along, and so it's a great lunch today. But thank you very much for coming. And particularly thank the jurors for being here, and I will introduce them in a few minutes. The Civil Jury Project was established about 3 years ago as a 5-year project at NYU School of Law. It is the only center or project in the country devoted exclusively to studying why jury trials were so important to our founding fathers that they mentioned it in the Declaration of Independence, in Article 3 of the Constitution, and in 3 of the Bill of Rights. It's the only one of the rights we have as citizens of this democracy which is mentioned that many times in our founding documents. The jury is so much a part of the architecture of courthouses in this country that there's not a courtroom that doesn't have a jury box in it. So it's part of our system of democracy, and it's in our DNA in this country, particularly when you think that this country is the only democracy in the world that guarantees citizens a right to trial by jury of civil cases. Yet, the problem is illustrated by this slide, which shows the dramatic decrease in the number of jury trials that have taken place in the United States in federal courts from 1962, when the number of jury trials per judge was 10, and it has now dropped on average. The average federal judge last year tried 2 jury cases. These figures also show dramatically, that's the red line, the decline in jury trials from 10 to around 2. And the blue line shows the decrease in bench trials. I did not know when we started the jury project that bench trials were dropping faster than jury trials, which is probably the best proof that those who defend jury trials can offer to rebut the argument, well, jury trials are dropping because they are too expensive and because they are too long. It takes too long to get there, it takes too long to get a decision, and the decision you get may be crazy and out of whack. You cannot trust a jury. If that were the case, then you would expect the bench trials not to be declining as fast or faster than jury trials, but they are. And every lawyer in this room will tell you that a bench trial is just as expensive as a jury trial, and may even last longer because judges tend to try bench trials whenever it's convenient for them. 2 days this week, 3 days next week, a half a day on Friday. So the lawyers end up spending more time starting and stopping when there is a bench trial. And this same pattern exists in the Northern District of Ohio. Last year, the average judge in this district tried only 1.45, less than 2, jury trials, and less than 0.36 of 1%, less than a half of 1% bench trials, which means a lot of judges did not try any jury cases and tried no bench trials last year. One might argue, well, that's because the number of cases being filed has dropped. So to make sure we don't build that into the draft, here's something that shows the percentage of cases, civil cases filed in federal court that are terminated either by jury trial or bench trial. And you can see here it's the same pattern, a dropping percentage. And this accounts for, of course, a smaller number or larger number of cases actually being filed. Something is happening on dockets to make the number of dispositions by jury or judge in an actual trial drop. The same pattern of the percentage of terminations occurs in state court. These are the figures for the Ohio state courts throughout the state of Ohio are the red line, and the blue line is your county here to show also that the percentage of cases being terminated by trials are dropping. So the Civil Jury Projects was set up. One of the first things we did is began to contact judges around the country. We have now 275 judicial advisors, state and federal judges around the country that we communicate with, that participate in our programs, and that are helping us decide, why is this happening? Do we care whether it's happening? And if so, what can be done about it? And among our early judicial advisors are 2 judges here that I would like to welcome and have say a few words. Judge Polster has to leave at 12:30, and I told him he would be out of here promptly by then. So Judge Polster was one of our early judicial advisors. Dan, would you say a few words?
Thanks very much, Steve, and I apologize, I do have to leave to get to the airport. So I joined the advisory group because I, along with all of us on the bench, we think the jury system is a great one. We don't want to lose it. If we don't do something, we will, and we won't have lawyers who won't know how to do them, and we won't have judges who know how to do them, and then we'll really be in bad shape. And I just hosted a group of fine soldiers from Israel yesterday, and I brought them into my courtroom, and I said, okay, you're going to see one big difference between an American courtroom and an Israeli one. It's right there, that jury box. And they could not understand why this great, powerful country of ours turns over such important decisions to men and women off the street. So I tried to explain to them why it works and why the product of 6 or 8 or 12 people, each one will observe something different and remember something different, and then come back in and have to engage respectfully and listen to each other. Why do we think that produces a good result, and it's the best system in the world? But we could lose it, and that would be a real tragedy. So that's why I joined the project, and I applaud all of you for coming, and quickly thank Steve for starting this and for making us all think about it.
Thank you, Judge. And I'd like to introduce Judge Gahn, who is a Chief District Judge, sitting right there, also a judicial advisor of the project, who I met with early when I came. To set these things up, I've got to go first and have a lunch at the federal courthouse. Then I got to come back to the place and have a lunch at the state courthouse and get the judges on board. And then it's, once I've been trying jury cases for 50 years. And I worked for the last 10 years as part of bar organizations trying to save jury trials. I was co-chair of BOTA's Save Our Juries Committee. And what I realized 5 or 6 years ago is that bar lawyers are not capable of doing this by ourselves. And Everyone views it as we were self-interested. Trial lawyers were self-interested in perpetuating what's going on. We're slow to make changes and to innovate. And really, the only way, and besides, we're busy. And you go to these fancy places and meet a couple of times a year. You think about saving jury trials for an hour on Friday afternoon at a committee meeting. On Saturday, you're thinking about your tea time. On Sunday, your tee off time, your golf time. And on Sunday, you're thinking about catching a plane home and you're dogging cases for the following week. And then we don't hear from these lawyers. They don't work on the project for another 4 or 5 months. This is trying to have a sustained effort that lasts all year. We began with the judges, and also we came back here after our meeting with the federal judge, and we made thanks to Judge Russo, who I'd like now to hit the chief judge of the state courts, because he was very kind and scheduled a lunch, let us host a lunch at his courthouse. And Judge Russo.
Yeah, thanks, Steve. So I'll just say three. When I received the phone call and I had a chance to sit, I stand here speaking on behalf of my bench. So there are 34 of us judges. And the very first thing that jumped out at me is, I'm aware of the fact that trials are down. And I understand that they're down in Cuyahoga County around the United States, and why is it? So when it became important for me, for my bench, and for the judges who work there, it was concerning that aspect right off the bat. The second aspect, well, for all of you who practice in that courtroom, right? All of you who are trained and have the skill, and that art, as I was saying to Mr. Tucker, that art is dying, right? We have the new lawyers coming in, and they don't have an experience in front of a judge, an argument, in order to consider to hone those skills of being a good trial lawyer. And so that was my second concern for all of you. I thank those of you who are participating and have jumped to the table here. The third is you citizens, you jurors who are sitting here, because it affects you in 2 ways. One, that constitutional right that we talk about, because it could be you that is accused of doing something, or being charged with something, or being alleged to have violated a contract. And you could be sitting in the seat hoping that those jurors that you're picking are someone who is going to be able to hear the truth of what's the matter before them. But it's also you who are here as jurors who stood up and came to the court for your civic duty, right? The civic duty of coming to serve as a juror. So the whole idea is important to us, so important here in Cuyahoga County that this young gentleman's coming back for our 8th judicial conference. And for those of you who don't know, we as judges and lawyers in this area, the federal court, common pleas, and all the other courts, we get together every 18 months with lawyers and try to look at what's going on in the judicial system to see if we need to change something. And we have breakout sessions to talk about things that are so important. And again, this young gentleman is going to be one of those breakout sessions to start to talk about what is going on in Cuyahoga County, in the state of Ohio, and in the United States. So I appreciate the opportunity to be here today as well.
Thank you very much.
And I have to apologize because I have one of my colleagues who is here, one of my favorite. Judge Kathleen Satula is here, and so she's from my bench as well, and was with us when we had the initial opportunity to speak in the Common Pleas Court, and I appreciate the judge being here as well today.
Thank you, Judge. Thank you, Judge Rousseau, for your comments. Well, let me mention kind of briefly what we have accomplished thus far in the Civil Jury Project, and before we get into our program, which is to put the jurors on a panel and learn from them about their experience, what can be improved, what they like, what they dislike. We have created at the Civil Jury Project 2 websites, distinct websites. This is the one for judges, lawyers, and academics. We have 65 law professors around the country that serve as academic advisors to our project, advise us on the kind of empirical research that they are doing and that could be done on dispute resolution in general and jury trials in particular. And this, as I mentioned, we have 250 academic advisors, and also we have about 35 jury consultant advisors. We have dozens of projects going on that are described on the website, the most notable of which I'll just mention. We do a lot of empirical research. We did a survey of over 1,000 non-lawyers, and what we discovered to our great surprise was that 80% of the people who are not lawyers are unaware of those graphs that I showed you. Their impression is that for the last 10 years there's been an explosion of litigation, of cases being filed, and of trials. I guess they get that from either the tort reform movement, the lawsuit abuse movement, or popular media. But their impression, 80% of the people in this country do not know our dirty little secret, and that is that most of these beautiful buildings that are being built as courthouses in this country are dark during a workday week. The lights are out in the courtrooms. The doors are locked. You can shoot a cannon through the hall of most federal courthouses in this country and not hit anyone on a Wednesday afternoon or Monday afternoon, anytime. But that's not known. And so one of the things we're trying to do is publicize the fact, publicize those graph lines so people can see we have a problem here. The second thing is people don't understand where the right to jury trial came from. And once they understand that it's mentioned 5 times in our founding doctrine, and that it is the only civic duty that our Constitution demands of the average citizen. You've got to serve on the jury trial. You can go to jail if you don't obey the subpoena, the summons to report to jury for jury duty. We don't make people vote. We don't make people anymore serve in the military. The one thing we ask of our citizens in this democracy, regardless of your wealth or your whatever, is that you serve on a jury, whether that be for a few days or a few weeks or a few months. So once people understand where the right to jury trial came from, they are much more likely and understand also that the reason our founders wanted jury trials in civil cases was to protect the little guy from the powerful governmental authority. They had a king back then that was denying them the right to jury trials and was insisting that they go to trial before judges that the king appointed and that the king instructed to convict people in those days. And juries were the people that could not be bought, they couldn't be instructed, they couldn't all be jailed, and they would acquit people who deserved to be acquitted for exercising other rights. So if you study the history of the jury trial, you understand that our founding fathers thought it was the best way to protect every other right they were giving us from government overreach, which means in this day we live in, where there's every night you turn on TV, there's not a night you don't turn on TV where you don't hear someone talking about the importance of the rule of law, and that someone is doing something that is against the rule of law. That's great for us, but we understand that juries are the main way the rule of law gets preserved. We have reviewed thousands of material business contracts filed with the SEC by public companies. We took a 6-month period, reviewed over 5,000 contracts, and discovered that 57% of the contracts do not contain a jury waiver clause or an arbitration clause, which suggests that the majority of American companies still, when it comes to their disputes with their co-equals in business-to-business material contracts, want a jury to resolve their disputes. Yes, in consumer contracts and contracts of adhesion, they may not want a jury, but in big contracts with co-equals, they want a jury trial. And we've begun interviewing general counsel to find out why. And what we are hearing is that the bloom is off the bud on arbitration as a method of resolving disputes. These general counsel are telling us, including most recently the Exxon general counsel who was there for a decade, that arbitration is too expensive. You pay 3 judges $750 an hour. They let the case go on forever. They split the baby ultimately, and what they do is totally unappealable to a higher authority. So the judges, these general counsel who originally spoke up loudly against jury trials are now seeing the light and coming back. We put on programs around the country for judges primarily and lawyers, and lunches like this to communicate the importance of trial by jury. We have hosted thus far three all-day workshops for judges, state and federal, around the country at NYU in New York, where we divide the program into 4 sections. Jury selection, how can we make it better and more reliable and less intrusive and quicker on the jurors? Care and feeding of jurors, what are good hours, what they need to be told about when the trial's going to end, and the care and feeding of jurors, we call it, or Jurors' Bill of Rights. They have some rights too. To get instructions at the beginning of the case rather than the end of the case, to be instructed in plain English rather than gobbledygook. There's a 3rd section on innovations to use at trial itself. And then finally, and very importantly, we have been in the forefront of the training of young advocates. So there is a wave of interest around the country in how we can train lawyers to try lawsuits, because if that skill is lost, then there will be no trials. And judges have told us around the country they would like to try more cases, but the lawyers don't want to do it anymore. And the reason many of them don't want to do it is they don't know how to do it. That is a shame, and if we don't stop that, so how do we deal with it? How do you train young advocates when you have let the grass like we just saw there, so few jury trials? Well, one of the things we are doing is encouraging judges to adopt young lawyer rules, where if a lawyer if you tell the court, a young lawyer in practice less than 5 years or 10 years or whatever they say, the various triggers, but a young lawyer is going to argue a motion, the judge will give that motion oral hearing. If the young lawyer is going to be the lead lawyer at a trial, the judge will give that trial priority over other cases. Judges are buying into this. And it's not only a way of training young lawyers, it turns out it's a way of getting more diversity in the lead lawyers who are sitting at counsel table. Because frequently, it's unfortunately, all the studies done show that women lawyers do the best writing of briefs and motions, but they don't share equally with men in time on their feet at trials. So we got to train female lawyers too, so we will have a diverse group of lawyers, and this young lawyer rule somehow accomplishes that. As I've said, this is our 13th jury improvement lunch. We have one like this in Columbus tomorrow. We have one, and we keep, the idea is if y'all like this, we will send you a survey this afternoon that we ask you to fill in. And if people like it and want to continue it, and volunteer to plan it. So we don't have to keep coming around and filling the hall. You will do it locally if you want to do something like this. Maybe annually or biannually or whatever you decide you want to do it. But Houston is in May having its 4th jury improvement lunch. Dallas is having its 3rd jury improvement lunch. And Seattle is having its 2nd. So we're beginning to get a repeat. And we will, by the fall, we will have gone to every major city in the country and held a luncheon like this. We publish a monthly newsletter that are available on our website. You will get that newsletter because we now have your email addresses. We maintain a 2nd website called We the People, We the Jury. And what we do here is 2 things. One, we give, if you come to this site and you check this, serve jury duty before, we get hundreds of people coming to this site. They are then asked, administered a questionnaire, which they fill out. Many of them, and everyone who comes to this site, by and large, loves having been a jury. So we get raves about jury duty. They're coming to this site because it was a great experience, and they want to continue the experience. So we go contact those people, they give us their contact information. We send camera crews around the country to get testimonials from jurors about how great the experience was. And so that's the served on jury before. If they get this, if they click here, currently serving on jury, they're told, you shouldn't be here. The judge told you not to be here. Finish your jury duty and then come back. And if they click over here, receive a jury summons, and we get thousands clicking there, what they're clicking there is to figure out how to get out of serving jury duty. And the first thing they are met with are videos from prominent judges and citizens and people who have actually served on juries, short snippets, telling them, don't throw away your summons. You are about to have the most exciting experience a citizen in this country can have. And people who have had it want to do it again and again and again. And so you should not go, and it's basically trying to improve the yield of summons that are served to get jurors around the country. When we get people to the people who have, I forgot to say that the people who have served on a jury, we get them by these little business cards which the judges give to jurors as they discharge them, telling them, thank you for your service. You can visit this site and answer this questionnaire and tell us about your experience. We're going to get from some jurors in a few minutes their answers. And then we have an active social media presence for attracting people who are surfing the web for a way to get out of jury duty. So I'm pleased to say that earlier this week, the NYU Law School decided to make this 5-year project a permanent center, and we will have an ongoing center on how to improve jury trials in this country. But today our focus is how to improve them right here in federal and state court. We know that there are alternative ways of resolving disputes, but we want to deal with the criticisms of resolving them by jury trials. And I would now like to ask the following jurors to come forward, and they have agreed. First, I'll introduce we have some jurors. I want to thank the jurors who are here, and this is going to be, the only instruction I want to give you all, I need to get where I'm not in someone's way, is that we do not want you talking about your deliberations, the particulars of your deliberation. We do not want you to talk about particular judges or particular facts cases, because what happens in the jury room stays in the jury room. And we don't want some lawyers complaining that there's something wrong with the trial. Okay, so talk about the process, length, what can be improved in the next trial. So let me ask you this, Mr. Brennan, how long was your trial?
I think it was 3 days.
And Ms. Mollenhauer, how long was yours?
3 days.
Same trial. You were in the same trial. Who else was on that trial? Mr. Phelps?
1 day.
1 day. Ms. Phillips?
3 days.
3 days.
4 days.
4 days. Mr. Pruitt?
6.
6. Mr. Schmidt?
4.
4. Okay. So no one had to serve multiple weeks in civil cases, and that we are finding out also is very common in most civil cases. 90% of the cases tried in this country are tried in state court, so you all the state court jurors. We couldn't get any federal court jurors here in the time we had to plan for this lunch because there's not a lot of action going on in the federal court in civil cases. So when you got your subpoenas, your summons for jury duty, Mr. Brennan, what did you feel? Were you anxious to do it or anxious to figure out
I
how?
was surprised because my brother had just gotten his like about a month before, and I've never done common police, but I've done municipal. So yeah, I looked at it as an excitement. I've worked the polls all the time, so I figured civic duty is pretty important.
Okay, and Ms. Mollenhauer.
I had actually just told friends that I thought you guys lost my card. I hadn't been called for 20 years and had not done it the first time. So I was a little apprehensive, but I decided to go forward and say something new.
And Mr. Phelps.
Yeah, this was my first time. I received it begrudgingly, but I decided to go forward with it.
Ms. Phillips?
Well, I have received the invitation for 3 times, and every time there was something and never went to the actual jury duty. And this was a federal, civil federal.
Steve,
So it was very
do
interesting.
you mind if they pull the microphone?
Yeah, you need to pull the
If you
microphone,
don't
sorry.
mind doing that for
And
us?
if you, they're not in a box for everyone, so when you speak, pull the mic to you.
Thank you.
Mr. Pruitt?
Well, I had not received a notice for 30 years, and I'm self-employed currently, so when I did get the notice, of course, I'm thinking, well, how am I going to work this into my schedule? So I was apprehensive about it, but that changed once I participated.
Mr. Robinson?
What was the question again?
When you got the summons, did you try to figure out how to get out of it?
No.
You came. Had you done it before?
No, I haven't. This is the first time.
And Mr. Schmidt?
This is my 5th time. I think it's my civil responsibility, and I hope this never goes away. What you showed me today scares me.
Well, let me ask you this. Does anyone here not want to do it again? Okay, you would all gladly do it again, right? Because it was a great experience by and large, an experience you enjoyed. When you got to the courthouse for jury selection, how much time did you spend in the jury assembly room before you were sent to an actual courthouse for a dire or jury selection?
I think it was less than an hour. It was pretty quick.
We were the first group called first day.
Okay. Mr. Felt?
Mine was 1 day of waiting, and on the second day I was called.
About 2 hours.
Mr. Pruitt?
4 hours of waiting.
Mr. Robinson?
About 2 days.
Huh?
2 days.
How long?
2 days.
Before you were called to a courtroom?
Yep.
Or the trial? Before you were called to a courtroom, you waited 2 days. And Mr. Schmidt?
1 day.
So that time you waited, do you have any suggestions on how we could improve your using that time? Yes, sir.
Having done this 5 times, been a foreman 3 times, I truly believe as a foreman, there's a role and responsibility to support the process. And just because of my background in management and administration, I understand how to organize a group of people. And I've been in juries where the foreman let people crosstalk, wasn't organized, and I believe that a foreman should have the ability to understand what his role is, how to organize the thoughts, and actually control the jury in the process. That's just my own personal thoughts.
Who else was the foreman? Was he the only foreman we had? Oh, we have 3 foremen here. So let me ask you about, I'm skipping to the end. How was the foreman selected? Did the judge select you, or did you select the foreman yourself?
We selected ourselves.
You were allowed to select yourself. Sometimes judges will pick
We
the
were
foreman. If you're in a
selected
certain
by-
chair, you get...
Our peers selected us.
Okay. And they select, you had done it before a lot. How did you get selected, Mr. Pruitt?
I beg your pardon?
Well, how did you campaign for being, did you campaign for it?
Well, being an educator for many years, I'm familiar with and comfortable working with people, organizing them, developing coherency that Mr. Schmidt was discussing. And so I had a thought going forward that I would be interested in this position. I did say to the jurors that I wanted them to work with me if I was going to do it. And it was an excellent opportunity.
Mr. Brennan, how about you? How did you get selected?
We started talking, I won't use the word deliberation. We started talking a little bit, you could see the way it was going, and nobody seemed to want to do it, so I just kind of volunteered my service.
Okay, fair enough. Now, when you get to the courtroom, there's this process where you're asked questions. In the trials you were in, was it the lawyer asking the questions or the judge asking the questions, or both? You know, to find out whether you had any Bias? Both in your court? Both. And did you think the question, did anyone think that lasted too long, or was anything about that process that made you uncomfortable, or that you think could be improved? Yes, sir, Mr. Schmidt.
Prior to even going into the courtroom, having spent a day with other jurors that weren't on trial, many of them tried to figure out how to get out of it. I'm just telling you. And while I was even in the juror room, many thought, how could they say something so that either the defendant or plaintiff lawyer would not choose them? I found that disturbing. Truly, I think, again, I say it's my civil responsibility, and I believe that. But I think people don't feel comfortable there. They don't want to be there. That's my judgment on most of the people I talk to. And even in the room, people were making comments that they thought that would kick them out of the case.
Okay, Mr. Robinson, did you have anything to say then?
No.
Okay, Mr. Pruitt?
Yes. In my situation, the plaintiff's attorneys, well, both attorneys asked a number of questions, and as they continued asking questions, it became more and more apparent that the kind of trial was going to be. They were all based on medical issues. And it took 2 days to seat the jury because many of the individuals who were in those positions had medical issues that more or less pertain to this trial. So they were bumped. And another thing that I discovered was in this kind of a trial, if you were a scientist or particularly an engineer, you would get booted.
Or a lawyer.
Yes. And one of the jurors just mentioned that the attorneys did not like that type of individual, not personally, but their career, because of the fact that they were very cut and dry. So that's what I was told, on the side.
Okay. During that selection process, do you think that between the judge and the lawyers, they asked the right questions to disclose any hidden biases of the people who were on the jury? I'm not talking necessarily about your own, but maybe, did you think the questioning made sense? Were they asking the right questions?
I believe they were. However, as I said, when there were 2 individuals who had positions in which they were working as engineers, and they answered all the questions correctly. I mean, they had all the right answers, but they got bumped, so they weren't there the next day, so that took us an extra day.
All right. Were any of you in trials where the judge gave you instructions at the beginning of the case about what to look for? Or did that all come at the end? At the end of the trial, typically at the end of the trial, the judge gives instructions. This is a case, you've got to prove, the plaintiff's got to prove this, the burden of proof is here. Did any of the judges in your cases give you those instructions at the beginning of the case?
Our judge did.
Did you find that helpful?
Yeah, very helpful.
When they finally gave you the instructions at the end of the case, were you given a written copy of them? Each of you have a written copy, or only the foreman get a copy? Ms. Phillips?
Yes.
Each of you got a copy of the instructions.
Actually, it was very interesting because I have to keep looking at it, and one of the sentences was, regardless of your personal opinion, you have to follow the law. And I keep reading it and reading it, because that was the most important thing.
To you.
My personal, opinion was different.
And when were you given that instruction? At the end. Did you have a copy of it? You had a copy. Everyone was given a copy.
Yes.
Is that true or not?
Yes.
True. Not in your case. In your court, the cases you were in, were you allowed to take notes?
No.
I did.
No.
Yes.
Yes.
3 no's.
No.
Your yes? No?
Yes.
Yes.
Yeah.
And we did specifically ask.
Asked the bailiff said no.
You did specifically ask, you were turned down. So would you prefer, do you think it makes sense in cases in the future And there's a debate about this, whether jurors should be allowed to take notes.
Absolutely. We want you to do a good job and make sure.
Why not? So, and one of the things that you know, that's interesting, that's getting improved, one of the things we're studying in this country, is how to make service on, what lawyers do during a trial is teach. We try to teach you about facts. One could try to convince you to, but we teach also about various things. And one of the things we are told is that, you know, if you give students, we give jurors the same tools that we give students in an educational institution, like the ability to take notes and take their notes with them into the deliberation so they consult their notes. The ability, was anyone allowed in your cases to ask questions during the case? Well, there's another innovation that's done in a lot of courtrooms in the country. I would say now about almost 50% of the cases, civil cases tried in this country, the judges allow the jurors not to orally ask the questions, but submit them in writing to the witnesses. So if you don't understand something, you submit it, which, you know, in a class you can ask your professor questions, right? So why can't jurors ask the witnesses questions? But that apparently has not been done here. Would any of you have wanted to ask questions?
Yes.
Well, I did ask several questions. I raised my hand and the judge allowed me to do that.
Oh, you did ask questions?
I did, I had a couple.
Orally?
Yes.
To the witnesses?
For clarification.
Okay, so that's good. You could just ask them to clarify testimony?
Yes.
Was that helpful?
It was, but again, we weren't able to take notes. And I think one of the interesting things with this case was, and I'm wondering, you know, again, I was in education for 3 decades, and I hear what you're saying about the note-taking. However, sitting in that jury for those 4 days, the judge told us initially, he said, first of all, don't talk about the case. And that kept bringing us back to center whenever we left that room. He said that all the time. And the other thing he told us was that to use common sense as we looked at the evidence. And we were bombarded from both sides for those 4 days with evidence. And we also had a half a dozen expert witnesses, one of which was a video conference. And I found it very interesting because in listening to the expert witness, initially they established credibility. And then they would go through and present their expertise on a particular item that was of great interest in this trial. And then they would continue to talk further, and then when they were cross-examined, of course, their credibility immediately, cross-examination was to disrupt that whole thing and just dismantle it. So sitting there as a juror, you're beginning to feel buoyed up and thinking, all right, this sounds very logical. This man is an expert witness, very logical what he's saying. But then it's all dismantled. So I don't know. I mean, in going through this for 4 days, we had so much information. Perhaps taking notes would have been helpful, but things kept moving at a very rapid pace. So.
All right. A criticism, by the way, that we hear from jurors all the time is the lawyers repeat themselves too often.
Yes.
But was that a problem in any of your cases? So, Ms. Mullen, what was, you had the problem of repetition too?
Without going into detail, I would say, God forbid anybody needs a nephrectomy, I can tell you how to do it. Yeah, to the point of nausea. That was just too much. And it really lost our attention.
Ms. Brennan?
Can I kind of dovetail
Sure.
on that? As one who takes notes during sermons, I love taking notes. However, I'm going to violate one of your rules from the start. In the process of your talk, it was great how the recall around the room brought things to mind that you may have, I forgot about that. And it allows the jury to work as one. It kind of forces that, because of what she may remember that I didn't remember, that, and I
So you're
thought that was
saying that-
very helpful, and there was no notes involved.
So you're saying that, and one of the arguments against allowing jurors to take notes, many of them are, we have some courts that are halfway. They say you can take the notes, but you can't take them back into the jury room for fear that the note keeper is going to have an oversized influence on what the jury does. Because, you know, when you begin discussing it with 12 people, one's going to say, I have it right here, it's right in my notes, I took notes during that, and that you're supposed to rely on your own memory and your own recollection. And most of the times when jurors are allowed to take notes, the judges instruct them, you know, you can take your notes back in there, but rely on everyone's got their own memory and that's what counts, not what's in one juror's notes. So that is true, that happens sometimes. But people say that just the act of taking notes, like you take them in sermons, keeps you awake, keeps you engaged. The ability to ask questions, by the way, lets the lawyers know. One of the reasons we repeat things so often is we have no idea what we're getting through. You know, you're taught as an educator that repeating yourself is a way to teach people sometimes. You repeat until they finally get it. And so a lot of lawyers do that. Let me ask you about this issue with technology in the courtroom. Did you have was a lot of stuff displayed on the screen? Did people have video depositions, for example? They did in your case. Video deposition. Did they?
Somebody called from India.
And you had someone call in, a witness by telephone. Anything about the technology in the courtroom that you liked or didn't like or would improve it for you?
That was fine.
The judge told you at the beginning of the case that you were not to use your electronic devices to do any extracurricular research by Googling anything or going to the web or doing any of that. What's in evidence is what's in the courtroom. Was that instruction hard? Were you tempted at least to go Google something about the case?
I thought about it.
I did it after the fact.
After the fact, you did.
I learned a lot that I wished I would have known during the case.
A lot that you wish was known during the
Yeah.
case, that you learned afterwards.
Because it was precedent on another trial that this one built on. And if I had known the facts from that one, it would have helped this one significantly, I believe.
Okay? So the judge must not have allowed you to be told about that because some rule of evidence or something, which is frequently the case. But there, you did learn things afterwards. And Ms. Phillips?
Yes, same thing. It was actually, this was depending on another case. And I, for one, never even thought about going to court. But afterwards, I did. And I want to go back to the jury selection that everybody talked about.
Yeah.
Not thinking of. It just happened in the case that I was involved. I was right in the middle of the room where these two defendants and they were there, these two people. I walked in the lab and they were working in the lab. And I don't know, they asked very detailed questions about my job. And I'm sure they picked me just because I was in that environment. They didn't exclude me, they actually included me.
Because you were in the
Because
lab.
I was right there, I was the third person in the group. And I think that was, effective. And later on, I went and I did Google about these two people, which I trained them for every day. And I wish I had more information about the case.
Okay, the judge also, probably at the beginning of the trial, tells jurors something that's always struck me as being not what we do in education, and that is he tells you not to discuss the case with each other or discuss anything about the case with each other. That you to say that for when you're all together at deliberations. But of course, you know, when you go to a class at a university or something, and you go out of a class, you say, that lecture sucked, or the lecture was great, and I didn't understand what they were talking about, or something like that. Students learn by talking to each other about what they hear. And so there have been some that suggest that one innovation to make jury service more enjoyable, more engaging, and get a better result, we should allow jurors to talk about it as long as they are together when they're talking. And as long as they don't take any votes and make up their mind until they hear it all. So would you have enjoyed the opportunity? Do you think it would have been valuable to you to discuss things with your fellow jurors as you were going along?
You know, I think that
Go ahead, Mr. Schmidt.
I think it would speed up the process if it was done appropriately, because when we did go into deliberation, individuals had different viewpoints, and I think those viewpoints could have been discussed earlier, and we had to hash out a lot of those viewpoints amongst us to come to a verdict.
Mr. Pruitt.
I'm not certain as to whether I would go in that direction, for the reason that, as I mentioned with the expert witnesses, I began to feel that things were moving in a certain direction, and then that all changed. And so, you know, just with human nature, I think we start to talk about things, and you're going to have the pros and the cons, and generally, one of those people are going to have the ability to sway your opinion, or the stronger of those two opinions may hold. I think there are a lot of things that need to be considered there before making that kind of a decision. And personally, I did want to talk about it, but as I went through the trial, and I found myself vacillating up and down based on what I was hearing, I felt that it was better to wait until, as I was instructed, and then once we got into the chambers, then to have a discussion.
So while you bring up the subject of experts, and both sides have experts in many of these cases. Did you have experts in your case? Everyone has an expert on two sides. In Australia, they have a practice in court. They don't have jury trials, but they have bench trials. They have a practice called hot tubbing, where they put the two experts on the witness stand at the same time. They're both sitting up there. And they're talking to each other and responding to each other. Now, I've never seen that done in a trial in this country. But what judges have done in this country is put experts back to back. So the plaintiff's expert goes first, and then the next witness is the defense expert. So you were hearing the experts at the same time. Now, that's not such a big problem in a 2-day trial or a 3-day trial. But in a longer trial that goes on for weeks, it might be advantageous to have experts testifying together so the jury can contrast them right then. Would that have helped you with the experts or not?
I think it may have. I mean, personally, being in education, I'm swayed by information that I find to be factual, accurate. So I have to look at my own, through my own eyes. And I'm speaking from my own personal experience in that regard. But that may have been, for me, a better solution.
One of the complaints we hear about jury trials frequently is that the person that has the better lawyer wins. That jurors are impressed by great advocacy, great trial lawyers, and that if you hire the right lawyer, you can win. There's been a lot of research on that, and I for one believe that what matters probably more than the lawyer, a lot more than the lawyer, is the facts of the case. Do any of you think that the lawyers in the case you were in were so unequally matched that it made a difference? Mr. Schmidt?
The defendant decided to be his own lawyer.
Oh,
That was a huge mistake. He didn't even submit the evidence for the other lawyer to look at prior to the case, and obviously it was taken out of, he had all this information set up, he had a board set up, and the plaintiff's lawyer went to the judge and said, I never saw any of this, and it was ruled out. And we never knew what his case was, and he was behind the 8 ball from that point on.
Mr. Robinson?
Yeah, we have authority, he was representing himself, we also have authority to represent him. And didn't sway me on my decision at the end of the trial, because he's the big retainer.
Anyone else have a comment on how important was it? Ms.
I
Phillips?
don't think the lawyer made that much of a difference, as the opinion of the juror depends on the case that I was involved in. Because we thought that one of them were much better than the other person. But unfortunately, it didn't go that way.
It didn't go, and so in your case, the party that had the worst lawyer won. That's very interesting. Anyone else have any comments on that subject? How important is the lawyer as opposed to the facts?
I thought it was good, the critique afterwards was all over. The judge came in and told us that they will be out there if you want to talk to them. And I gladly spoke to them. And I thought it was a good civil discourse on telling them things that came up that they might have been better on and things like that. But I thought they were equal, the two sides.
But you actually gave them a critique.
Yeah, the judge came in, like when we were finished, he came in to thank us, and he said, the plaintiff lawyers will be out there if you want, if they meet your eye, you want to get a critique. So I don't know if anybody else, I was the last one out of the room, and I stood there and talked to them for
Did you talk to the lawyers on both sides or just one side?
just the one side.
Anyone else talk to the lawyers after the case? Mr. Pruitt?
Yes, the judge came in with both lawyers, and they were very conversational. They asked for feedback. They indicated that they were really trying to do their job to the best of their ability. And it was interesting, this is the second time this had come through the courts. We don't know why that happened, but there was a very large amount of money that was involved, and the plaintiff lost. But they were very professional in that regard.
So there's some judges that will allow the lawyers to talk to the jury in the courtroom, and there's some won't. And there's some jurors that, after a healthy debate and the deliberation, are tired. And they're anxious to get home, to get about their lives and return to verdict. They don't really, and it's awkward, I think. I've often felt it's awkward. If I'm the winning lawyer, it's awkward to have the losing lawyer there. If I'm the losing lawyer, I don't want the winning lawyer there. So it's kind of awkward for the lawyers who are involved to interact with the jury right in the courtroom. I mean, someone's very happy, someone's very upset. No one's really listening very closely to what you're saying. So that's why we have established that website, which I told you about, where you can go to after you calm down for a few days later, and enter questions about the proceeding. Let me talk about jury instructions. Did any of you have a problem understanding? Mr. Schmidt?
I had a problem with, we decided in favor of the plaintiff and gave actual damages. And then we came back, that was on a Friday, and we came back in on Monday to re-adjourn on punitive damages. And when we discussed punitive damages, we as a jury and me as a foreman did not understand the implications for actual damages and punitive damages. And my question to the lawyers and yourself is, my understanding after the case, and I looked this up, I Googled it, actual damages, the defendant didn't have to actually, they couldn't proceed to get him to pay, but with punitive damages, it could have been a lot more, and they would be forced to pay using, you know, their own house as paying off the sum. I don't know that for a fact, but end result is when we learned from the judge afterwards, and we really lowballed the punitive damages, we as jurors said if we would have known that, we would have increased the punitive damages significantly. So I'm just sharing that with you, and that's something I didn't know, and I wished I would have known.
Okay.
In this case,
Okay, let me ask you this, did anyone realize when you were awarding damages, who awarded damages? You did, you, Ms. Phillips, you awarded, anyone else award damages? Two awarded damages. Did you take into account that the lawyer representing the plaintiff might get a percentage of the amount awarded?
yes.
Did any of you think about that?
And
You
that's
knew
why-
about that. You
We
were
did
smart
know
enough to
that,
figure
and
that
that's
out.
why we didn't go further on the punitive damages, but after sight, I would have, all of us agreed that we would have made it, we would have doubled the actual damages with punitive damages, just for your knowledge. And we didn't understand that. And my question is, as a lawyer, how do you present actual and punitive so you're not self-serving yourself? Because you are getting a percentage, but informing the jurors of the law and how it works. That was a part that I think all of you need to look at that.
How to argue punitive damages better.
Yeah. And how to present it so that we as jurors understand the difference between actual and punitive and how they work.
It's a hard thing for lawyers to do.
I believe that, and I don't know if judges are supposed to provide that, but boy, that would be very helpful.
The lawyers typically are allowed, punitive damages are also called exemplary damages. And they're called exemplary damages because they are to teach an example to someone. And if you want to send an example, set an example, teach an example, you then send a message.
We would have sent the message if we'd have known that.
And that's the way the lawyer has to argue. Send a message, ladies and gentlemen, that we will not. Now, you know, not every jury trial involves this. But one of the things that's so important about jury trials is that what you do takes place in a public courtroom. And the public knows, they don't care about a lot of cases. I suspect a trial that lasts for a few days is not something that's going to make it into the papers. But as you know, anyone who reads the paper understands that the Me Too movement now is one of my best allies in trying to preserve jury trials, because what the bad actors have done is tried to assure confidentiality, or that the dispute is arbitrated and not tried in a jury case, so it's out. So in arbitration, you can have it confidential. What a jury does when it comes out with that verdict is totally public, and the newspaper can be there, and you can send an example. And so, you know, there are a lot of people who say these agreements that try to keep disputes in arbitration or confidential are antithetical to a democracy and our system of justice. We need to get things out in the public. And when you do return a verdict, it is public, and people, so how much do you really think it's worth to take someone's arm off when you took the wrong arm off, to physically, sexually assault someone? How much should they have to pay for that? And those are all important parts and businesses even. I mean, you know, I've represented a lot of defendants too in cases, and what goes on in the boardroom and the executive suite is, we don't want to do that because we may have a jury's going to hold us accountable someday. I mean, we are all, business operates in the shadow of knowing that if worse happens, They may have to come in and get 12 people drawn from a cross-section of the community like y'all, deciding how much they have to pay to teach them a lesson. And no one wants to be confronted with that. With the instructions, did any of you have to ask the judge when you were deliberating for any further instructions or information?
Twice.
Twice in your case? Did the judge give you the help you needed?
Most definitely.
Ms. Phillips?
You know, in our case, people, the juror, wanted to reward much more than I wanted. All agreed on the verdict, but we did not agree on the amount. And that's the time that we sent a letter to the judge. People were asking if they can reward for traveling and housing and all these things.
Did the judge respond to those questions?
Yes, don't worry about that.
Were your cases in cases where you had documents, exhibits, a lot of exhibits in the jury room? Did you have what you needed in the jury room?
I felt we did, other than the fact that, again, the defendant wasn't allowed to submit that, so it was pretty one-sided.
Okay. Now we're going to end. I'm going to end, and then I'm going to ask if there are any questions because we're a little early. We've got 5 more minutes, but let me ask you to go down the line. And here's a hypothetical question. By the way, last week, for your entertainment, I was with a group at the TED conference in Vancouver. You know what the TED lectures are. And we had a Jeffersonian dinner. And the question at the dinner that we had to ask was, if we were writing a constitution for a new democracy, would we insert in it the right to jury trial in civil cases or not? And we deliberated as a jury that evening till we never reached a unanimous verdict because there was one holdout. But the mere process of deliberating was so enlightening, having to listen to something. It just occurred to me going through it. I've never been on a jury, but going through that process of like a dinner where you have to go around the table and you have to vote. No one has to. This is the only time in our lives, your lives as a citizen, you get to do that. People of all walks of life, people you would never work with or talk to otherwise. It's quite an interesting experience. So the question I put to everyone at the table we began with at that dinner was, if you were sued for more money than you had, a lot more money, you were defended, would you want a trial by a judge or jury, or would you want it in a confidential private arbitration? Mr. Schmidt, what would you want?
I want a jury.
Mr. Robinson?
Jury.
Mr. Pruitt?
Jury.
Ms. Phillips?
Judge.
A judge. I'm coming back. Will you tell us why?
I felt extremely uncomfortable with the jury people, my colleagues that we can't hear.
We pull them.
I was very uncomfortable with the other member of my group. And I thought it was very unfair what they talked about, the material, about the money. When they talk about $200,000, they were saying it's nothing. We have to reward $500,000. Why? They had no explanation. And the other thing was that they were extremely in rush to finish the business and go home. And that, at 5:30, I almost passed out. And that's why somebody said, let's come back tomorrow and deliberate, because I just couldn't take it anymore. I thought if the judge was judging this person, the verdict would have been different. I'm sorry.
That's no, you have raised, you see, I go to these luncheons, I tell you this from my 13. You raise a point that has never occurred to me. And I want to thank you for it. And that point is that maybe we should do something to tell the jurors, you are going to have to deliberate for a certain amount of time, regardless of whether you reach a verdict or not. So you're here for at least a day, or you're here for at least 2 days. And so talk it through thoroughly, rather than it never occurred to me that the pressure of having to get done and get out of there would cause people
Yes.
to compromise unfairly.
Yes. They were there, we all were there, we all are busy, I'm still working. Everybody was busy. But the fact that they wanted to finish it, the same day, we started deliberating about 2:30. At 5 o'clock, they were ready to finish it, and I was not. And I don't know, maybe I'm a strategic person, the money is more important to me than, just writing it on a piece of paper, or maybe I put myself in the position of the person who is have to pay.
Well, that's it. See, I think the judges got to rethink this whole thing, because the judges frequently are anxious to get the deliberation done and go on and do something else. To get the verdict returned, that's, efficient to do it quickly. But maybe we have to do something to
Or
protect.
maybe I just took the matter very seriously.
No,
I don't know.
you did it right.
I was really affected.
Mr. Phelps.
I sympathize with what you're saying, and I'm a little torn if I would choose a judge or a jury trial. I did have the same sense of, there was some.
I'm going to make it a little easier for you. You don't get to make that choice after you know who the judge is. Because if we knew who the judge was, we might gladly take a judge trial rather than a jury trial. But you're going to make the choice in advance. And remember, like in this county, how many state court judges are there? 25, 20? 34. 34. You can get one. And I guarantee you, of that 34, there's some that are not great, which is true in every jurisdiction.
But you just want to add something. You're right. Everybody is different. But at least I know I will judge education, not just by common, I hate to say common sense, but by carelessness.
And some emotion too. That's my primary hesitation. My trial was a corporation who had signed a contract with an individual consumer, and that corporation was trying to hold the consumer to the letter of the law, the contract. And the consumer's attorney, the defense attorney, said, "Hey, look, this contract's unreasonable. It shouldn't be considered enforceable." I found that it was an enforceable contract, whether the consumer understood it at the time he signed it or not. But I feel like my peers who overruled me, we had 7 people side with the defendant, 8 not. They I think made an emotional decision. I put myself in this person's shoes. This isn't fair. Let's get out of here. That shook my confidence a little bit, and I think that's why I'm sympathetic a little bit to what Ms. Phillips is saying.
It would really depend on what I was being accused of, but I think I would lean towards a judge for all the same reasons.
Okay, Mr. Brennan.
Since my peers are not as sensible as they once were, I would put, boy.
You could have gone either way. You don't know who's going to be on that jury with you.
And you don't know who's going to be the judge either.
But so many decisions are so much based on emotion. That really is an issue.
Does anyone here have any questions of the panel before we end today? If you do, holler out. Yes.
Mr. Schmidt, one of the things that you talked about was the difference between the 2 damages. On Friday, you had awarded damages, and Monday you came back with the punitive damages. At the time that you were awarding damages on Friday, were you aware that you would have the opportunity to award more damages, punitive damages?
No.
That's what I wanted to know. Thank you.
Yes?
Objections, sidebars, not being able to hear things. Did you have too many, too few? What did you think about objections? Whether you felt like things were hidden from you, things like
It wasn't an issue for, I mean, there was a few, but not that I found offensive.
And I think the judge instructed us if there was something pertinent, that we thought we needed to know.
No issue there.
Did anyone think their time was wasted while the judge was dealing with lawyers or anything like that?
No.
Thank you very much for coming. Thank you for coming.